In this session, we will continue our examination of the principles from the Employment Contract chapter. The Fair Labor Standards Act. This is a very important piece of federal legislation. It's often referred to as the FLSA. It was a federal law that was enacted in 1938 to provide fair compensation for employees. There are three primary provisions of the FLSA. We're going to talk about two of them, but the main ones here are ones that cover a requirement of a minimum wage. There's a requirement of paying overtime wages, and last is regulating child labor. We're going to look at the minimum wage and the overtime requirements. So the FLSA is pretty much covers all workplaces because its applicability is based on a connection to interstate commerce, and most all businesses or workplaces involve some degree interstate commerce. Now, the Fair Labor Standard Act only applies to employees. If an employer has hired an independent contractor, there's no obligation for them to provide a minimum wage or overtime payment to an independent contractor. And we talked about this as one of the reasons why an employer favors independent contractors over employees when we discussed the difference between employees and independent contractors in our agency discussion. And so here we're back to it. Independent contractors are not covered by the Fair Labor Standards Act. So everything we're about to talk to, these requirements are not going to apply to anybody that you have as a worker through an independent contractor relationship. Now, that comes with an asterisk beside it because, like we said in the agency discussion, that just because you label someone an independent contractor, just because you define that relationship as an independent contractor one, that's not dispositive. That doesn't mean that they're not subject to the Fair Labor Standards Act. Instead, you're going to look at the facts and circumstances of the relationship. And we talked about all those factors. You're going to look at who has the control. Are they working for other people? Who provides the tools? You're going to look at all those things, those factors, to determine whether it really is an independent contractor relationship or an employer-employee relationship. So under the FLSA, employers must compensate employees for all hours worked. So that's seems like a very elementary topic. You would think, sure, you know when everybody's working. But it's not always as easy as you may think. There are many instances in which you've got to be careful that all hours worked are being tracked, especially as technology has grown and made it easier for you to work outside of the office, outside of your typical workspace. So you've got to compensate for all hours worked. Well, if you're a server, you know all the hours you're working. You're there at the restaurant when you're clocked in and you're taking orders, you're bringing drinks, you're refilling drinks, you're running food to them, you're cleaning up. All of that's going to be time working. But it becomes a little less clear when you get outside of a relationship like that. So if you work in a sales position and you're at home at night, but you still have access on your cell phone or you have access to a computer. If you're able to log in from home on your computer, I can do that. I can log in from my home computer into my office. When I'm doing that, if you were somebody that was doing that, you may be engaging in time that you're working that you may not be considered on the clock because you're not at the workplace and your employer doesn't know about you working those hours. And so it's real easy to be at home, sitting at home at 9 o'clock on a Monday night, and your phone dings, and you go over, you pick it up, you swipe up on it, and you check your email, and you see that, oh, you got an email from Dan at the office. You see what Dan says, and it's something you need to respond to. And so you reply, and you start typing, and you type for 3 or 4 minutes, and you reply to Dan. You've technically been working from home. Are you being compensated for that time that you were sitting at home reading Dan's email and type in a response to it. More than likely, you're not. And so this is an area where it becomes hard to track and compensate for all hours that are worked. So the time at home, time on a cell phone. What about when you've called someone and you left somebody a message at the office? They call your office, they don't get you, you're driving home from work, but they call your cell phone. All of a sudden, then you're talking about work, you're doing work, you're returning or you're having that conversation that you tried to have during work hours. Is that time that you're being compensated for? More than likely not. And so again, FLSA says you've got to be compensating these employees for all the hours they're working. In these scenarios, it's hard to track those hours, and so you've got to be working with the employees to make sure that they are capturing that time on their timesheet so that they're being compensated for all time work. There are many lawsuits that come out where employers say, or employees sue employers for not paying them for all hours worked, and they claim, well, I worked all these hours because every day on the way home from the office in my 30-minute drive home, I was taking phone calls, and I was taking phone calls on the way to the office in the morning. And so I was working an hour a day and not getting paid for it. And because I was working an hour each day and not being paid for it in my drive time, I was going over 40 hours a week and not being compensated at the overtime rate. So you can subject yourself to these lawsuits and these claims of unpaid wages and sometimes unpaid overtime wages because of these instances of times that you're not tracking. So another time when it comes up is on meal and rest breaks. If somebody's taking a lunch break or somebody's taking a rest break, you've got to be sure to properly handle the payment during that break. If they are taking a meal break and it is exclusively relieved 100% of all responsibilities, then it's possible to have the employee take an unpaid lunch break. But if the employee is confined to the employer's position and they're on call, or they are have some obligation for the employer during the break, then they must be paid for it because they're not technically on a break. They're not relieved of all their duties. If they're being required to answer the phone still if it rings or to be on call in case it rings, they're not completely relieved of their duties. So being on call, what about if you're this happens all the time in like the nursing field. If you're a nurse and you're off on the weekend, but you're on call, when you're on call, are you working or not? Well, that comes down to the sense again, are you relieved of your obligations? If you're on call and just have to be available to answer the phone, well, once you're just hanging out and you're at home or you're at the movies, you're not working such that you would be entitled to compensation. But once you got the phone call, then you're engaged in employment because you're talking because of your job. And if you have to go into the office, then at that point, you're engaged again and you're working. You're not relieved of any duty when you're taking the call, and then when you're doing any act after the call, that's going to be time that you've got to be being paid for. But just being on call, if you're on call all weekend and you don't receive any phone calls, or you don't have to go do any work, then that is not, you're not going to be owed any time for that weekend. So these are some of the areas in which you can have some traps, I guess is a good way of putting it, in which you could have an employee working but not being compensated for the time that they're working. So for all hours worked, the employees must be paid at least the minimum wage. There's a federal minimum wage, and in the currently in the United States, it's set at $7.25 per hour. So every employee must be paid at least $7.25 per hour for work between hours 1 and 40. And as we'll talk about in a minute, for over hours, anytime worked in excess of 40, the employee may be entitled to overtime wages. So just because the federal wage is set at $7.25 an hour, that does not preclude states or even cities from enacting higher minimum wages. and you have had a number of states that have enacted higher minimum wages, and you've had even cities that have gone in and enacted higher minimum wages. So employees are free to work as many hours as they want. However, all non-exempt employees must be paid overtime at the rate of at least 1.5 times the regular rate of pay for all hours that they work that's above or in excess of 40 hours in a week. And so you see the term non-exempt. Remember that. We're going to talk about what does that mean in a couple of slides. But this is getting into the overtime requirement. So for anybody that works over 40 hours is entitled to increased wages for the extra time they've worked. So the example here is that John works 45 hours. His hourly regular wage is $10 an hour. So John would be entitled to 40 hours at $10 an hour for a total of $400. But then John would be entitled to overtime wages for 5 hours, and his overtime hourly wage would be $15 an hour, because that's 10 times 1.5. And so John's wages for those 5 hours of overtime would be $75. So John's weekly wages are $475, which is $25 higher than if John had been paid straight $10 an hour for the 45 hours that he worked. So we use the term regular rate of pay. So in the example we just gave, John's regular rate of pay is $10 per hour. But it's possible that the regular rate of pay could be different than the hourly wage rate, because the hourly wage rate may increase when you have additional pay, such as a non-discretionary bonus. If you have a non-discretionary bonus, that would be an example would be a bonus based on attendance, or it's something that if you meet a metric, then you don't have any discretion in whether you pay out the bonus or not. So the example here is an attendance, or if you you do some amount of sales, you're entitled to a bonus. Any of those type things are non-discretionary in the sense that if you hit whatever the metric is, you're entitled to the bonus. So the non-discretionary bonuses are going to be additional pay that's added in to affect your regular rate of pay. That would in turn have result in you having a higher overtime wage. So on these overtime requirements for public entities, this would be like cities and counties, the FLSA provides some relief. As public entities, it's hard. They have a set budget. And so if you have to have employees have overtime, especially let's take a city has a portion of their labor force is police officers. And police officers, as you well know, work and respond to emergencies. And so it's hard to anticipate every emergency situation that could happen in a given month, year, or week even. And so it's possible that you have employees, police officers who will work overtime. And if that's the scenario, then as a public employer, you would be entitled to use a comp system as an alternative to paying overtime wages. And when we say a comp system, it's exactly what you would expect. It's where the employee receives additional leave time instead of overtime wages. And the leave time that they receive is at that 1.5 rate. So if they work 3 hours overtime, they would be entitled to 4.5 hours of leave time. So it helps insulate these public entities from having their budget just blown apart by overtime wages. If you'll remember, I said that we were going to talk about the exempt versus non-exempt employee. And so here we are at that slide. So I said overtime wages on the previous slide. We said that overtime wages apply to non-exempt employees. And that is true. So employees are either classified under the Fair Labor Standards Act as exempt or non-exempt. So as an exempt employee, it's exactly like you would expect. That means you're exempt from the overtime requirements and or the minimum wage requirements. So if you are an exempt employee, then you can work more than 40 hours and you're not entitled to any additional compensation. Me as a lawyer, I'm exempt from the FLSA. And so I do not get paid extra wages for any time that I work over 40 hours in a given week. But non-exempt employees would be entitled to overtime wages for time that they worked in excess of 40 hours a week. So an example of one of the exemptions is that there is an exemption, these are called the white collar exemptions is what they refer to it, but executive, administrative, and professional employees are exempt. Now to be exempt, they've got to meet 3 requirements. You're paid a minimum salary amount. Currently, that amount is that you've got to be paid at least $455 per week. Then the second requirement is you've got to be paid on a salary basis. And by salary basis, they're meaning that the number or your pay is not affected by the amount of time you work. So you're truly salary in the sense that if you work 55 hours, you get paid the same amount as if you work 25 hours. Now, there are some exceptions to the salary basis requirement, but generally you've got to be paid on a salary as opposed to paid an hourly amount. And then you've got to meet the duties test. And these duties tests all vary based on whether it's an executive, administrative, or a professional employee. But there are certain requirements where a lot of them go to a requirement that you exercise some degree of autonomy and independence and control in your as an employee. And so if you've got some of that control or autonomy, then a lot of times you're going to meet the duties test. So unless a specific exemption applies, like one of the administrative, executive, or professional exemptions, unless you meet an exemption, then the employee is going to be a non-exempt employee and would thus be entitled to overtime and minimum wage protections under the FLSA. So the last point here is we talked about one of the requirements being that you're paid a certain amount per week. And that was set at $455 and still is. Back in 2016, I believe it was, President Obama and his Department of Labor proposed an increase to that rule. And I think it has not been increased since the early 2000s, like maybe 2004. But anyway, they proposed an increase. And their thought is that time has gone by and $455 today isn't as high as it was back in 2004 when that level was set. And that's probably true. And so their point is that there are people that were never intended to be classified as exempt employees that are now able to be classified as exempt because they meet now this $455 requirement. Whereas 15 years ago or 13 years ago, whatever, they didn't meet that number because wages were more depressed than they are today. So they proposed to increase the salary limit from $455 to $913. Their efforts were ultimately stayed or stopped by a federal judge who granted an injunction against enforcement of the new rule. They found that the $913 rule more or less exceeded their scope under the regulation that they were given. The regulation doing this exceeded the authority that they were given by the statute. And so at the current time, the salary level remains at $455. And following President Obama, now President Trump, his administration has backed off on this rule and is not seeking to enforce it at this current time. So the salary level remains at $455 per week.